Hello and welcome to the 2024 update on wills, probate, estate administration. And now I say my name is Ken Vercammen and I'm an attorney in Edison, New Jersey. So when I'm finished, for the people who are live, I will answer questions. If someone's not live, well, you probably should have a consult with an attorney. So, but just to start off with, people often ask us, well, what happens if I don't have a will, or why do I need to will? Doesn't everything go to my spouse or my children? I goes, yes, but that's not really doing planning, because you typically will also want to have a power of attorney if you become disabled, a living will if you're in a hospital. But more importantly, if someone doesn't have a will, or if it wasn't done right, sometimes people, like the surrogate says, the problems we see is when people try to do it themselves. It's like doing their own electrical work. If they do their own electrical work right, well, they save money, but most people do it wrong and they burn their house down. So if they don't have a will, it's not signed right. Let's say there's 3 children. All 3 of the children have to agree upon who is going to be the administrator of the estate, and they have to sign a renunciation in front of a notary, and then have it signed in front of a file with the surrogate at a fee. Okay, drag the other chairs in, like I said. Okay, yeah. All right. Okay, so let's, if there's no will, there could be 3 kids. What if one of them says, I'm not signing this renunciation? Well, then the person who wants to become the administrator of the estate has to spend a lot of money to have filed a complaint or to show cause in the Superior Court. And then notices have to be sent to every person on the planet that would have inherited. It's better to have a will where you decide who gets your stuff, and really sometimes who doesn't get your stuff. We're handling an estate where a fellow passed away. He had 3 kids, 1 predeceased, and only saw his grandkid twice in 17 years. Well, because if you pass away without a will, that means that person gets 1/3 of everything, and it creates more work. So the whole idea is planning ahead of time. No one would, if they knew you were going on vacation for a week, wouldn't decide on Friday afternoon, okay, where should I go? I know I got a week off. Let's see, you can't drive to the airport like 30 years ago and goes, I'm going on a trip somewhere. Where am I going to go? Let's see. Also, if there's no will, that means the administrator has to pay for what's called the surety bond. It's like an insurance policy. The fee is like $2,000 for each year. Why spend the money? If there's minor children, both parents are gone. A total stranger at the courthouse, the Superior Court judge determine who gets custody. So, if someone has minor children, who do you want to have? A lot of times I can't decide who the right person is. He goes, okay, I understand that. Who don't you want to have custody of your kids? I remember decades ago when my son was first born, my wife goes, it was kind of surprising. She goes, how about your brother? She goes, how about my mom? Your mom's like kind of kooky. I mean, she's good to watch the baby, but she'd be bringing the kid to church 3 times a day. She goes, what about your brother? My brother Steve, he's single, lives down the shore. He can't raise a kid. Frankly, I couldn't raise a kid. So the whole idea is trying to make things easier for everyone. Pre-COVID, what the old system was to make an appointment and have you come into the law office and you would take a pen and fill out stuff in pen, and some people would mail it in. I couldn't understand the people's handwriting, and even if I couldn't, sometimes I can. And then plus, I'm in Edison, Middlesex County. A lot of times I couldn't understand, the one person, the husband's last name was different from the wife's name. The person who's the guardian was different from that person. So logistically, so during COVID, when you couldn't come in, even before that, we started emailing the questionnaire, and we found out for 95% of people that was easier. We now have like 2 different questionnaires. Okay, the one questionnaire is the regular will questionnaire, and it asks questions like about guardians for minor children, and but for someone who's retired, it's pretty easy. Who's executor 1? Who's executor 2? What's your name and who gets your stuff? And then questions to ask. So logistically, to do things now, we email out the will questionnaire, and then we email it again. If someone says, I have Gmail, it goes into my junk mail. Someone types it up, then I call them and I go over what we recommend. And after my wife retired, she wanted to be like she don't want to be called the bookkeeper. She wants to be called the business manager, and she gets the money. It's funny, confidentiality. Let's see, I can't discuss anything with anyone. And before my wife actually had a role in the office, one time she says, how come you didn't tell me my Uncle Ernie came to see you? Okay, we're trying to explain confidentiality. People, I go, none of your business. She goes, but he's my uncle. I goes, don't matter who it is. They can tell you, but I can't discuss it with them. It's some kind of, I might run into someone at ShopRite, and sometimes I'm wondering whether or not I should acknowledge that I know him or not, because maybe, people think, why do you know the lawyer? Are you in trouble? No, I just did the will. Okay, so what's the information you typically want, are going to provide the attorney? Well, we don't need a lot of stuff, because believe it or not, New Jersey reduced the taxes. They did away with the New Jersey estate tax. 10 years ago, every penny over $675,000, it was a huge tax. Now, there's no New Jersey estate tax. However, there is a federal estate tax, but that starts at $13 million. How many people do you know that have $13 million? I'd say, I could probably think of 10 of my friends that if you combine, don't got $13 million. New Jersey does have an inheritance tax, but there's no tax if it's going to spouse, children, grandchildren, parents, stepchildren. Money's going to charity, no tax. Brothers and sisters, the first $25,000 is tax free. After that is tax 11%. Every other human though is taxed at 15%. So in some of the estates, there's no tax that is due. We still got to file. If there's real estate, we still have to file the inheritance tax form, get a waiver, file it with the county clerk's office before, sometimes before the person gets their money. For the people that sometimes we have seniors that don't say, I'm not good with the email or internet. I go, so no problem. We can work with you 2 ways. You have a grandkid or a grandchild. Let's say tell them, hey, if you come over, they live the next town over. You come over and visit me in the next 3 weeks. I'm going to give you $5,000. If the grandkid goes, I'm too busy to see what you live 2 towns over. You can't come and visit your grandfather, grandmother for an hour. No problem. I just won't leave you anything. I'll say because now when someone says no, I don't have anything, and they have to handwrite it, hey, then we're going to charge more, because that means I have to do more, and the more someone does, the less I have to do. Okay, now it's best to have an executor 1 and executor 2. You don't want to have joint executors. That creates almost twice as much work. When it's joint executors, that means that 2 people got to do everything. 2 people got to go to surrogate's office. 2 people have to open up the accounts at the bank. 2 people got to sign every check. 2 people got to go to closings, etc. And that's where people get along. Sometimes you get 2 executors where, we had an estate we were in court on where, these brothers didn't get along. Let's see, one brother would say the sky's blue, the other one says no, the sky's gray. You're stupid. You've always been stupid. I mean, the judge said, fellas, why don't you guys go outside? Go have a cup of coffee and talk about fun stuff you did. You guys are spending all these court costs and fees on, furniture in a house. It's used furniture. It's not worth stuff. But that's how sometimes people are. So, occasionally, someone will say, "Listen, I don't have anyone in the United States that can do this or speak English. Will you, as the attorney, be the executor?" I goes, "Well, only if you put it in writing that you want us." The reason why that's important is we got court rules and we have court memos and ethics opinion. And there was an ethics opinion that said the attorney should not be naming themselves as the executor unless there's a relationship with the person specifically asked. Because what was happening in the early 80s is some of these attorneys in New Brunswick, and they were automatically putting themselves in the will. Oh, I give my trusted advisor, Saul Blumberg, as executor, and they barely knew the person. But some people, on the other hand, sometimes, if someone already has a will, sometimes people do updates because they realize the persons that they picked as the executor can no longer do the job. Our rule of thumb is, can the executor drive to the courthouse because they require a personal appearance typically? Can they drive to a bank? Can they walk up a flight of steps? It's not that we're anti-senior citizen or, people that can't. It goes, we're practical. I mean, the government doesn't let people drive that are blind or have certain medical conditions because it's unsafe for the rest of the world. Okay. Now, I mentioned that since New Jersey did away with the estate tax, I don't need to know people's accounts when we're doing wills. Accounts are not listed in the will. Typically most people say, hey, my accounts are going to spouse, are divided amongst kids. However, there are certain assets do not, quote, pass on to the will. So some assets go direct, when someone passes, go directly to the survivor, even if the will says otherwise. So very commonly a house is owned husband and wife. If one of them passes, automatically goes to the survivor. Let's say once a month we get called by a family. They'll say, oftentimes husband died. They want to come in, wife, for mom to probate the will. I goes, well, was there anything that was only in his name with no beneficiary? I go, no. I goes, okay, I just saved you $200 and a trip to New Brunswick because you don't have to probate. So, if there's bank accounts that are POD, joint tenancy, TOD, transfer upon death, automatically go to that person. The will, even if the will says, if the will says everything goes to the Yellow Dog Society because I like dogs better than my kids, but their kids are on the bank accounts and who's ever on the accounts. Other assets passed by contract, IRA, 401k, life insurance, annuities. So we do recommend that for all of, when someone has accounts, it's a good, liquid accounts, it's a good idea to put down beneficiary 1, beneficiary 2, and then print it out and put it with your will. You still always have a will because there's always accounts that don't have a beneficiary. But I'm a believer still in paper where your will has to be the original will made to probate, not a photocopy, not a scanned version. But it's still, good idea. You get a printout of the accounts and say, my beneficiary 1 is this, beneficiary 2. This way, it makes the executor's job easier. When people are mourning, there shouldn't be one more thing they have to deal with, saying, what should I do? So, in your will, you set forth who the beneficiaries are. And if that person passes, who gets that person's share? You don't want to have things what we call dangling, where if someone passes, who gets that person's share? If it's not clear, then you have to file a complaint order, show cause, and have a superior court judge rule on that, and that costs lots of money. The idea is, as much as we like our superior court judges, they have lots of work to do. Right? We always have clauses that say there is if there's someone under the age of 21 or 25, sometimes someone says the money gets held in a trust account until they're 21 or 25, but it can be used for college education, maintenance, welfare. Remember, it's your decision who gets your stuff. And more, I call them mature people, because the word senior citizen is kind of like almost a dirty word. Mature people, they might say, hey, listen, let's say my kids are grown, they got their own house. I would rather leave it to my grandkids for college, etc. But and again, it's your idea to do with your money what you want. Some people have what's called specific bequests. So sometimes the ladies will say, hey, whatever jewelry I have, I want it to go to my daughter, my granddaughter, not to my son, because my son will bring, my mom's jewelry to cash for gold. What do you give me for this junk? Other people, sometimes have something that's been in the family and they want it to pass down to someone else rather than it go, to cash for gold. Sometimes someone has, sometimes what people think is worth stuff, collectibles, ain't worth much. Let's say I looked one time up what my, baseball cards that had been in the attic for 30 years were worth. They weren't worth that much. Let's say people bought collectible Hummels, whatever. They're only collectible when you paid for the cash register and the place collected your money, but they're not usually worth stuff. I'd say, ironically, I did tell my son to throw away all stupid Pokemon cards, and then it turned out 20 years later, yeah, they were worth something. Who would have thought? Oh, Brandon, get rid of that stuff. Collect baseball cards instead. They're worth something. Some people want to leave a specific amount, a specific amount to a charity. Now, I support giving to charities, but it is better to give a set amount. And say, if my estate is worth more than this, they get X. When you give a charity a percentage, not only does the Attorney General have to be notified, but the Attorney General has to be provided with an accounting, and the estate is not done until the Attorney General's office approves, and they're late. Sometimes slow in approving stuff. We have an estate where some of the documents are in Hebrew, and it goes like the question of the executive, is the Attorney General going to require that this or this? It goes, it depends, but these charities are only getting 2% of an estate, so they're only getting maybe 6-8 grand themselves, so maybe they don't want it. So those are some ideas of specific bequests. Sometimes we have what we call the reverse specific bequest. I say, I leave nothing to this person. You don't leave them $1. You don't put a reason. I leave nothing to this person. We worked on we were doing a will last year, and the client says, do I have to treat all my kids equally? He goes, nah. Listen, again, if you want to leave everything to the Old Dog Society, that's your right. What's your concern? She goes, well, one of my sons lives on the West Coast. We don't hear from him much. Okay, let me ask you a question. Did he send you a card or call you on your birthday, Mother's Day, or Christmas? No. I go, why would you leave this bum anything? And that's the kind of person that the day you die, they're going to be saying, where's my money? I want my money. I want my money now. I'd say, and that's another reason why it's a good idea sometimes to have an attorney do it, because when you have an attorney, you sign in a law office, you have the attorney as the witness, their staff, and they're independent. when the judges see something that was signed in the hospital where it was prepared by one kid and signed by that kid's friends, and that kid is getting more, well, that smells. And by the way, if I'm not, again, some people aren't good with the internet, their kids type up stuff for them. Hey, I want to help, especially if some people can't get around, but I need to talk to them, and they have to tell me what is on that paper. Even if someone says whatever my son or daughter says, no, that's not good enough. They got to tell me what they want. They can't, then I can't do it. I mean, I'm not. I got to follow the rules just like everyone else. So. But the thing is that when you have an attorney, and someone one time asked me to get involved with a will contest, and I asked him he goes, okay, it was his father. He wasn't left anything by his father. Okay, how many times did you visit Dad in the past 3 years? Well, who lived also knew. No, we had a falling out. Okay. How many times did you call him or send him a letter saying, listen, maybe we should get together. I said some things. Nothing. I goes, okay, who did the will? And I see a particular attorney. And one time I said, listen, I can't stand this guy, but he's a very good attorney. And your chances of convincing a judge that attorney's a screw up ain't very good. Maybe you want to spend the money challenging it. There's a possibility that maybe they'll give you something. I don't know. You know them better than me. But knowing that, if you challenge it, the judge may say you have no grounds to challenge it. I'm making you pay all the court costs. Someone one time wanted to challenge it. He goes, how much is it going to cost me? I goes, write this. I go, write this down. He goes, I don't know. Let's see. Or how much you want to spend? One time, I don't do any matrimonial, but people don't want to spend money. I go, well, and then give them what they want. So, if you don't have a will, get one done. Let's see. Don't be a putter-offer like Carl. Let's see. Carl was this retired engineer, and some of these engineer types are ones that when they got their car, they would read the manual from cover to cover. And then when they got the first generation laptop, there was this book that came with it that was this thick. Let's see, they would read it from cover to cover. Let's see, well, so this guy Carl, you should do this, this, and this. They were still on estate tax. Well, I want to read more up on it. I go to the car. You don't need to read anything. Listen, I went to law school. I passed the bar. I wrote a book on this. I lectured to the attorneys. You don't need to. Well, I want to read up. Okay, fine. Don't hear back. 2 years later, daughter calls. Oh, my dad passed. Does our office have his will? No. He never paid us. He wanted to read up on stuff. So, in a way, if you don't do the right planning, you're screwing your family. Is that what your goal is, to give them more stress? Let's say, my theme is I don't want any stress at all. I would. So that's a little bit about wills. We get a call once a week. I want to get a revocable trust done. Okay. And I call people. I goes, okay, why do you think you need to spend between $4,000 and $6,000 setting up a revocable trust and not owning these assets anymore? Let's say, my mother-in-law, called me different time. I want to come in and get a trust done. Okay, were you watching Susie Orman on TV? She goes, oh yes. Susie Orman is right. If you live in New York, California, Florida, where the probate process is very, very, very complicated. Let's see. New Jersey, probate costs about $180. I ask people, why do you think you need to? And it's not just signing a trust. It's changing how things are owned. And even if you change how your house is owned, different assets, you still need to have a will anyway. And interestingly, certain assets can't be owned by a trust. One of those is an IRA, because if you change ownership of the IRA from yourself to a trust, then there's like bad tax ramifications. So there's people that are trust salesmen. They try to sell these people on $6,000 trust packages with fancy books and stuff like that. But I consider myself an honest person, and I would feel bad if I tried to convince one of my friends' moms to set up a trust package that they don't really need. Let's see, a revocable trust. Then the people say, why do you think you need to have a trust? In the event I have to go into a nursing home. Well, that's a different animal. Say lions and tigers are different animals, but they're completely different. To protect assets from nursing home, that's called an irrevocable trust. Okay, sometimes they call it Medicaid trust. So, who pays for someone else to go to the nursing home? You pay yourself. Let's see. The only time the government pays is if you are on Medicaid, which is welfare. Welfare only pays if you have no assets on your own. To do that, the attorneys that I know that do these sophisticated Medicaid trusts, they charge between 12 and 15 grand. All the assets are retitled, new deeds, and 5 years has to go by. If someone goes to a nursing home, then all that money, 12, 15 grand went for naught. Their selling point, though, is that if it's done right and more than 5 years go by, a nursing home costs more than 12 grand a month. Let's see. Sitting in my office, daughter brings her mom in, and the daughters do most of the talking, because the daughters are saying, let's see, my mom wants to protect her assets. Now, I could smell. Mom had to tell the daughter wants to protect her inheritance. This is not my first day doing this. Let's see. First thing I said goes, okay, daughter, you can take out long-term care insurance on your mom's behalf. Well, I don't want to spend my money. Yeah, I didn't think so. Let's see. And then the daughter asked me the question. Let's see. Well, what would you do? Let's see. Well, what would I do? I go, I want to go into the nicest facility that exists with the money that I have. My grandmother lived to almost 105. Let's see. If you don't have any money, you don't get into the nice nursing home. You'll get into the crappy, dirty one that takes that. But if you have some money, then you start off being private pay. Then when you run out of money, it goes there. Let's say the people who are over 50 remember in the olden days before everyone had a cell phone. So in the olden days, my grandmother's in the nursing home. She's 100-something years old. She had her own apartment until she was in her late 90s. But I'm doing a 10-mile running race in Freehold. My grandmother's the next 10 over in Lakewood on Route 9. And I say to my wife, hey, listen, wanted to drive down with the kids. We can see, they can see their great-grandmother while, she can still talk. And, meet me down here. I got, here's the address, okay, Fountain View. Okay, so my wife's driving down Route 9, probably had the gas station map in front of her to find Route 9 in Lakewood. And then she pulls in the parking lot of the nursing home. She goes to the front desk. Oh, I'm here to see Virginia Vercammens. And my wife looks around and goes, ew, this place is disgusting. Ew, it's like dirty and smells of pee. Oh, that's so sad. Just 2 years ago, Ken's grandma made us, spaghetti. And people behind the desk be like, not here. What do you mean not here? You lost my husband's grandmother? I got the note, Virginia Vercammen, room, second, Fountain View. Oh, this isn't Fountain View. Fountain View is down the road. This is Smelly View. So that's the story. I worked delivering newspapers. So delivering newspapers was work, and I had to deliver them in the rain. So, I want my father always said, I don't want to be a burden. And he goes, let's see, but you want to get the best care possible. So that tells you a little bit about trust. Let's see. Some people have special needs kids, and they should have what's called a special needs trust, because you don't want kids with special needs to get money outright. Some people, they don't have kids with special needs, but they're wayward. They could have an alcohol problem, drug problem, etc. So you can set up a trust. Again, within the will, we call it a testamentary trust, where they don't get their money outright. It gets held by someone, and it can pay for whatever their expenses. We handle the probate matter where the mom passed and she had 4 kids, but the one son was an alcoholic. So instead, what she said was, the money's going to the son, gets put into a trust. The daughter's going to be the trustee, and to pay for and it's a discretion. So this guy's ex-wife goes and has a complaint filed in the Superior Court saying, okay, I'm owed alimony and this. I want Judge you to compel the trust to pay me what I'm owed. I represent the estate. I said, Judge, the whole reason for setting up these kind of testamentary trusts is to protect it from everything, and that's what the law is. It's the only thing that protects assets from taxes and even from Medicaid. So this guy if this son had to go into a nursing home, Medicaid goes, okay, there's a trust fund set up for him. I goes, it's testamentary, it's discretionary. You can't touch it. Or I said the wife can't touch it. I don't want to say to the judge, you can't touch it, because the judge sometimes knows that, but sometimes the people in the courtroom think you're insulting the judge. But the judge says, Mr. Vercammen's right. That's the purpose of these kind of testamentary trusts. So that's why earlier I mentioned that for some of the younger people, you do it. Sometimes we'll say they get some money when they're 22, 25, and 30. I tell people, do you think, because we got to also protect young people from their friends and their others, because otherwise their friends would say, hey, let's go have a party. Let's have a party. All right. So the next topic we are going to talk about is the power of attorney. A will takes care of your assets if you pass away. What a power of attorney does is, while you are alive, you're giving the power to someone to be able to pay your bills and talk on your behalf legally. A power of attorney is important because even if 2 people were married, it doesn't legally give the spouse the power to do anything. We do a bunch of power of attorneys every July and August where kids are going off to college and they're 18. The parents goes, I'm told that legally, if I can't even call the college and say, hey, did my kid fail out or not? The kid's in an accident, calls the hospital. So in our powers of attorney, we also have clauses that deal with, that they can do stuff with real estate, bank accounts. Even we updated them for access to medical records under the HIPAA law. A power of attorney is effective either right away or only upon disability. If it is effective right away, that's called a durable power of attorney. It's durable. It's in effect the day you sign it. It stays into effect even if you become disabled. It only stops either if you die or a judge says it's no longer in effect. Some powers of attorney which we don't recommend are effective only upon disability, and those are called springing powers of attorney. I was trying to explain this to a client. He goes, "Kenny, listen, I'm a carpenter. I don't understand legal terms. Explain to me in carpenter terms what's the difference." Okay. The durable power of attorney, it's effective right away. You're putting your son as the guy in charge. That means that he can steal all your money right away. If it's effective only upon disability, he needs to know from a doctor before he steals all your money. Knowing that, you trust your son. He goes, "Oh, I trust my son with my life." Okay, good. Make it effective right away. That's the better way. Because if it's effective only upon disability, you have to go and prove to banks, and the banks are not easy to deal with a power of attorney where the person can't talk to them. We also now recommend a new power of attorney be signed every 5 years, because if it's something that's 19 years old, the bank might say, how do we know this is still good? If someone moves, a will that's done in New Jersey is valid in any other state, but a power of attorney might not be recognized by another state because their laws might be different. So if you move to another state, it's a good idea to take your documents to someone who's an attorney there and says, "Hey, is this what?" It's not even the word valid. Is this what is best for me? Is this what is best for me? Okay, that's the little bit about powers of attorney. Yeah. By the way, after the will is signed, it's only the original will is admitted to probate. It's still a good idea to scan it and email it to yourself, Executor 1, Executor 2, and then put it, goes, "Hey, the original's located at wherever you're going to keep it." Don't put it in a safe deposit box because people can't get to it on the weekends at night, and or in the spring or summer of 2020 in COVID. Bank goes, "Hey, we're closed. We do everything online. Well, I need to get into this box. You might have germs. You can't come in." The power of attorney. We recommend people scan it, email it to themselves, Agent 1, Agent 2, and email it to a financial advisor, accountant, anyone who kind of helps you out with your finances. This way, they already have it on file, and if they have any questions, they can talk to you as the agent. It's sometimes difficult where someone says, "Oh, by the way," they call the financial advisor. "My dad had a heart attack, he had a stroke. I need to access some of his funds, and I have a power of attorney." Financial advisor goes, "Who are you?" "I'm the son." "Well, I don't see anything on our record." So you send it ahead of time. Okay. Last thing we're going to talk about before we finish up is the living will advance directive. So, think of someone's in a coma, irreversible condition. They're never going to come out. You're giving instructions to hospitals and doctors what you want. Typically, you want the document really isn't for you. It's for your family so that they don't have to be almost traumatized by making the ultimate decision. Let's say, because anyone who's ever done it, I remember one time the person did not have family, so I was the person on their power of attorney. But the person didn't want to have a living will. "Oh, I'm afraid of having that." They think that's going to make them die. Well, so they don't have a living will. So the doctor goes to me Okay, routine. Should we remove life support today? Geez, doctor, I feel bad. I mean, the right decision is for someone who's 92 years old that's not going to open up their eyes again and sit up and talk. But you hate to be the one to say, yeah, go turn the switch off. Go ahead. I couldn't even do it on my first dog. And my wife, you go do it. I'm not, I'm gonna keep the dog home. So that's why you're doing the living will advance directive for your family, so that you've already made the decision. So if a day ever came where the hospital doctors say, okay, what should we do? They're holding up a document that says, this is what the person decided in 2024. Let's follow what they had expressed. So we took some language from the medical society. So basically, it goes, let's see, fluids and nutrition to be provided with help. 95% of people say, listen, there's no hope for me. I don't want to be on feeding tubes, etc. The next section deals with artificial machines. Probably 99% of people say, hey, listen, if there's no hope for me, I'm not going to talk again, then, I don't want to be on, we call pull the plug. New Jersey recently passed legislation called the Dying with Dignity Act. The Dying with Dignity Act is if someone is diagnosed with an incurable condition where they're probably going to pass away in the next 6 months, someone can take a pill under medical guidance to, end their life. So it's kind of funny when, but you're still picking someone in your living will to talk to doctors because you sign it. The doctors typically want to talk to one family member. And it's important to have the living will because you have a captain of ship for that. It doesn't have to be the same person as the executor. Sometimes someone will say, hey, I have my son as the executor because he's knowledgeable about finances, but this other child works as a nurse or is more familiar with medicine. I'll have them do it. Okay, fine, whatever someone wants. But it's important because without a living will, who decides? If there's one child, that's easy. If there's more than one, it ain't easy. And in our experience, a lot of time, sometimes there's a situation where one kid wasn't involved. Another kid was very involved, very helpful. All of a sudden, the mom or dad's in the hospital. All of a sudden, the hospital goes, the prognosis is bleak, maybe another week, probably less. And then the kid that wasn't involved comes back, marching into the room, says, okay, listen, I'm in charge and this is what we're going to do. And the answer is, no, you ain't in charge of anything because Mom signed a living will back in 2024 and you ain't in charge. This person's in charge. And you're lucky we even let you into the room because you weren't there to help out. Let's see, when you are needed. So and more we're as I mentioned, we're doing documents where someone goes, no, I'm gonna so and so is gonna get more than the other one. Sometimes not because they dislike them, but someone needs the money more. Lady goes, listen, I got 3 kids. I love all my 3 kids. Daughter number 1 is married to Dr. Rosenberg, the plastic surgeon. Their second house on LBI on the water is worth millions of dollars. Number 2 did okay. Number 3 married the bum. The bum doesn't pay child support. I would rather give more to the other one, or the other one's living in a house with me because otherwise she's going to be sleeping in the car. Some people give a a life estate or a temporary estate in the house, just so the person living in the house doesn't get kicked out. And that's a little bit about life estate. So, last thing in my last 20 seconds, this is not a legal document, but this is more. Some people prepare what's called a letter of instruction. A letter of instructions kind of like helps out the executor, saying, "Listen, I'd say, yeah, this is if I pass. These are what accounts I have, because assets are not listed in the will, but this is who my accountant is." Some people like pre-plan or pre-write out what they want as a funeral or some kind of service. So some people nowadays say, "I don't want to have a funeral. You can have a wake, you can have a party, a memorial service, but funerals are all usually sad. With that sad music." Some people go, I said, "Okay, you can do the wake, then I want to have a big party at the Elks Club, an open bar and subs, and and everyone gets to bring home a track trophy." My wife wants to get rid of them. Your letter of instruction also, it's kind of like break in case of something happens to me. You're giving, you're telling your family where your important papers are. This little lady did a handwritten letter of instruction saying, "Okay, these are my accounts, notify these people, and I have no other money, you don't have to look for it." That made the executive jobs sooner, but she was organized. Sometimes the difficulty is where, someone's not married, and one of their kids is because someone did when the old days when you would get a bank statement every quarterly or once a month, what accounts they are. Now when everything's done online, so some people in their letter of instruction like to have ways of saying, "Hey, these are where my secret accounts are." So I want to thank the people who watched on the internet Facebook machine. Have a good day.